Welcome everyone to this virtual roundtable organized by the NUS Center for Asian Legal Studies, or CALS. The director of CALS, Professor Jacqueline Neo, wanted me to say that this is a new series for CALS, but it's actually the 7th. This tells you how far into the year COVID-19 has brought us and how active CALS has been this past year. My name is Tjio, and I'm director of the E.W. Barker Center for Law and Business that is jointly doing this particular webinar with CALS. We have an interesting topic today on COVID-19 and contractual obligations. I want to first acknowledge how forward-looking Professor Mindy Chen Wishart was in holding the last of a series of comparative Asian contract law conferences on what the common law understands as the frustration of contracts. Perhaps that is why she is now Dean at Oxford. Some of our speakers today were here at NUS for that very conference almost a year ago now exactly, when the world was a very different place. They will today tell us how COVID-19 has resulted in a real-time experiment for different jurisdictions in dealing with supervening events. Representing the common law are Professors Dora Neo and Tjio, who are leading contract law academics in Singapore and Hong Kong respectively. Qiao is, however, today looking mainly at China, a civil law country. I look forward to what civilian countries have done and will be doing. And for that, we also have Professor Kwon Young-Joon from Seoul National University in South Korea, and Professor V.Munin Pongsapan, Dean of Thammasat University in Thailand. We have framed some questions for them to address, which includes both general legislative changes and also specific ones in particular areas like rental relief in their respective countries. In addition, there are other changes that may impact on contractual obligations, and we have asked the speakers to explore them and also to predict what future changes, some of which may well be permanent, we are likely to see as a result of COVID-19. So without further ado, I would like to first call on my wonderful colleague, Dora, to tell us what has been happening in Singapore.
Thank you very much, Hans, and good morning, everyone. It's a pleasure to be with you this morning. In Singapore, COVID-19 has severely disrupted daily lives and has had a devastating effect on businesses and the economy, as it has around the world. We have had a 2-month circuit breaker period, something like a lockdown, from April to June, and our movements were severely curtailed at that point. Many businesses were closed, and those of us who could worked from home. We are now in phase 2 of the safe reopening period, where many restrictions have been eased, but substantial ones still remain. So let me get to today's topic. If a supplier cannot deliver goods or a contractor cannot complete the job on time, can the other party sue them for breach of contract, or will they be able to escape liability by arguing that their inability to perform was due to COVID-19 and that they should be excused? I will look at this question in 3 parts by discussing first, frustration, second, force majeure, and then third, the new statute to deal with COVID-19 that we have in Singapore. In terms of the topic today, the first two parts are the existing legal norms, and the third is the legislative innovation. So let me start with frustration. Under the common law system, whether or not a person is excused from performance would depend on the doctrine of frustration, which deals with changes in circumstances after the contract has been entered into, but which are beyond the control of the parties. The test for frustration is whether or not the performance of the contract has become a radically different thing from what the parties had promised to do originally. This is a very narrow doctrine, and it is difficult to satisfy the test of frustration. The contract will not be frustrated just because performance has become more difficult or more costly or has become less profitable. For example, the Singapore courts have said that any increase in costs will have to be astronomical before the doctrine of frustration can operate, if at all. So a contract will be frustrated if it becomes impossible to perform. But normally, impossibility is hard to show because the court may find that one method of performance, even if it's impossible, other methods can still be used. But as COVID-19 is such an extreme and devastating event, it is likely that some contracts will really be impossible to perform and will be found to be frustrated. A contract will also be frustrated if performance becomes illegal, and this is especially relevant in the current situation, where illegality could take the form of contravening the regulations which have been put in place to control COVID-19. Frustration deals with contracts that were entered into before the pandemic started. But as it is a doctrine that deals with supervening events, contracts which have been entered into after COVID-19 will not be frustrated. And if parties want to provide for these contracts, they want to be sure what's going to happen, they would have to provide for these particular, for what is to happen in the contract, by the terms of the contract themselves. So the effect of frustration is that both parties are released from their obligation from the time of the frustrating event. And if there were any adjustments to be made, for example, if one person has paid a sum of money and the question is whether it should be refunded, then this will be something which will be dealt with under the Frustrated Contracts Act. So let me move on to the next part, which is on force majeure. Frustration operates by law, regardless of the intention of the parties. Sometimes the results can be uncertain. So for greater certainty, many parties may insert a force majeure clause in the contract. Under the common law system, force majeure doesn't have any specific meaning. It depends on the drafting of the clause. So parties who are unable to perform their contract because of COVID-19 may try to rely on a force majeure clause, and two questions will be asked. The first is, does the event fall within the force majeure clause? Does the event fall within the definition provided for in the clause? That's the first question. And the second question is, if it does, then what are the consequences provided for by the clause? So is the pandemic a force majeure event? We have to look at the force majeure clause in any particular contract to look at the definition of a force majeure event. So some contracts may have a list of items. For example, they may say that the force majeure event is if there is a flood or an earthquake or a typhoon. So if there is a defined list like that, and the list does not include virus attack or health epidemic or something similar, then in fact the COVID-19 pandemic may not be covered or will not be covered by the clause, and therefore the parties cannot rely on the force majeure clause. Even assuming that the pandemic is covered by the clause, then the next question is, what is to happen to the contract in this event? And sometimes the clause may provide that the parties' duty to perform may be suspended for a certain period, or they may provide that the parties are discharged from the contract, or if the inability to perform is for a prolonged period, then they may provide that the parties should go for negotiation or arbitration. So if a force majeure clause applies, then what happens would depend very much on the terms of the clause. So looking ahead to the future, if anybody is drafting a force majeure clause now, although in the past, the idea of a health pandemic may not have been in our minds to be put in this clause, certainly it's something to be included so that it is something that will be provided for in the future. Let me move on to talk about the COVID-19 Temporary Measures Act. This statute deals with various aspects of the COVID-19 crisis. And there is a particular part of the Act which gives temporary relief from the inability to perform contracts. And before I talk about the statute, let me just read you a quote from our Minister for Law. He said this: "You are looking at economic devastation, businesses destroyed, people's lives ruined. And in such a situation, you don't talk contract. You talk equity, you talk justice, you talk about what is the right thing to do. So, looking at the statute, a party who is unable to perform his contractual obligations due to a COVID-19 event may be able to get relief under the Act. This is a very wide-ranging act, and for the purposes of today's talk, I will just mention some of the more core provisions. So certain types of contract are stated as listed in the Act, and the Act only would apply in these situations. So some examples would be contracts for secured loan agreements granted to SMEs, construction contracts and supply contracts, event and tourism related contracts, hire purchase and conditional sale agreements, leases and licenses of non-residential property, etc. So, if a contracting party is unable to perform their obligations in relation to one of the specified types of contracts, then the other party cannot take certain types of actions against them for a prescribed period. And this prescribed period is a period of initially 6 months, starting from 20th April 2020. This means that this period will expire on the 19th of October 2020. Under the statute, there is a possibility that this period could be extended for up to a year. So what are some of the actions that must not be taken by the other party? The other party mustn't commence or continue an action in court against the non-performing party or against his guarantor. The aggrieved party also cannot commence arbitral proceedings under the Arbitration Act. He cannot enforce any security over any immovable property. He cannot repossess goods under any hire purchase agreement or retention of title agreement. And other instances include inability to terminate the contract for the payment of rent. So these are wide-ranging actions, and they are really meant to be a temporary protection for the person who is unable to perform. There are also special provisions against relief against forfeiture in various contracts, specific contracts like event contracts or tourism-related contract, where a person has paid a deposit, and the question is whether or not the deposit should be forfeited. And the answer is usually that there would be a period of time during which this should not be done. I will move on to talk about how to seek relief. And the non-performing party, in order to get relief under this act, must send a notice of relief to the other party, stating his inability to perform. And if the parties cannot agree, then the claim will be sent to a panel of assessors for determination, and the panel will decide on this. This is not a panel of judges. This is a panel of people appointed, and they would tend to be lawyers as well as academics. Some of my colleagues, for example, I think our moderator, Professor Tjio, is an assessor under this particular statute. So the assessors will decide on various matters. For example, for Section 5, which is the release of the inability to sue, the assessor will decide whether the case is one which falls within the scheduled types of contracts, and the assessor will decide whether or not the event is one that is caused by COVID-19. So this is quite a powerful role. And the decision of the assessor is final. No appeal is allowed. The parties will not be allowed to be represented by any advocate or solicitor at the hearing. Note that the legislative reliefs will not apply to contracts entered into after 25th of March 2020. And in fact, anybody who wants to draft a contract now would have to put in their own provisions, because this statute will not apply to protect them. Now, having known of this event, they should look after themselves by putting in the provisions under the contract. So what is the relationship between the legislative measures and the doctrine of force majeure or frustration? The point is that the measures only impose a moratorium. They are only a temporary relief, and this only would apply for the prescribed period. So after the period is over, questions of whether the contract has been frustrated, whether or not a force majeure clause would apply, those questions would still have to be decided. So these measures are temporary. The legislature wants to protect the economy, but not overly interfere with the freedom of contract. I can see that my time is almost up. So I think I will end here. And if there are any questions, I'll take them later. I'm certainly looking forward to hearing the other panelists on the situation in their countries. Thank you.
Thank you very much, Dora, for that excellent presentation. Like Dora says, I'm sure some of you have questions, but please save them to the end. You can use the Q&A facility on this webinar, and then we'll try and consolidate the questions after all the presenters have had their 15 minutes. I'd like to call on Qiao next. He's actually well known to us in Singapore because he's got a very well-known article on anticipatory breach that our Court of Appeal cited extensively.
Thank you, Hans. It's really a great pleasure to be here, and it's also very pleasure to see everyone here. The title of my today's presentation is Combating Various Judicial Lawmaking in the PRC. So as you can see from this title, I'm going to focus on the jurisdiction of mainland China. Now, unlike common law jurisdictions, mainland China legislature has not taken any actions to combat the pandemic. The reason is very simple, because it takes a long time for the legislature to pass a proper legislation. Instead, people's courts in China have taken quick actions to issue a great number of documents which contain rules which may change the previous rules of contract law, designed specifically for cases involving the pandemic. So that will be the focus of my presentation, and we will see how these documents, how these judicial rules have changed the existing law in China. Okay, all right. So, but first of all, I want to explain the nature of these documents issued by people's courts. And we all know that documents can be of various types, documents issued by courts. So basically, we can classify these documents into some broad categories. The first and the most important category is what is called judicial interpretation. Now, judicial interpretation can only be issued by Supreme People's Court. That is the highest court in China. And this judicial interpretation is binding. So it does have a formal legal binding force because it follows a set of procedures. It has to be approved by the Judicial Committee of the Supreme People's Court, and it has to follow strictly the procedures, and it has a unique identification code. So judicial interpretation is undoubtedly legally binding. That is possibly the best form of making binding law. However, in the case of the pandemic, Supreme People's Court choose not to issue judicial interpretations, but instead to issue what we can call judicial documents. These judicial documents have a dubious status because we cannot say they are formally binding. However, they are in fact followed by lower courts. So in fact, they are binding. They are binding in the sense that the lower courts will cite these documents in the decisions. They will follow the rules provided in these documents. So in fact, there is a de facto binding force in these documents. So as far as we can see, Supreme People's Court has so far issued 4 such documents. So Supreme People's Guiding Opinion number 1, number 2, number 3, and most recently, there is a notice on issues related to travel contracts. Now, if we turn to local people's courts, can they issue legally binding judicial documents? Now, that is again a difficult question because formally, local people's courts cannot issue legally binding documents or rules. They do not have the power to make laws, but in reality, it's quite different. So even if the Supreme People's Court has said explicitly that local people's court, including High People's Court, Intermediate People's Court, and all lower courts, they cannot issue judicial documents akin to judicial interpretations, but local courts are allowed to issue all the documents. So that is, I think, the what local courts are doing here. They try to issue documents which are said not to be judicial interpretations, but in fact, these documents can have actual legal effect, just as judicial interpretations do. So far we have 21 documents issued by High People's Courts in a number of provinces. I'm not looking at documents issued by further lower courts, because I think the 21 documents already show that what is most important in the issues dealt with by the Chinese judiciary. So we have the 4 Supreme People's Court judicial documents. We have 21 documents issued by High People's Court, and that is the basis on which I try to see whether the rules have made any change to existing law. Of course, these documents consist of a number of different provisions, so we cannot deal with all these provisions one by one in detail. Rather, what I'm trying to do next is to summarize some most important general themes or principles out of these documents. So, if we look at the structure of the substantive law in China, we see that there are 2 separate legal doctrines which might govern the situation where a contract performance is affected by the pandemic. One doctrine is called the doctrine of force majeure. The doctrine of force majeure can have 2 different legal consequences. One is that a party who breaches the contract because of the pandemic can be exempted from liability for breach of contract. And in this respect, the legal test is whether the contract performance is rendered impossible or the party is made unable to perform the contract. So it's a rather strict test. And this test has been used a lot in SARS case in 2002 and 2003. But courts and people often overlook that the doctrine of force majeure can also have another consequence. And that's the second consequence, which is one contracting party can terminate the whole contract by serving a notice to the other party if the pandemic or if the force majeure renders the purpose of contract unfulfillable. So if because of the pandemic, the purpose of the contract cannot be fulfilled, then one of the parties may terminate the whole contract by serving a notice. So here we can see that legal test is what I call contract purpose test. It is wider and more flexible than the impossibility test under the first consequence. Now, if we look at the documents issued by Supreme People's Court in response to the pandemic COVID-19, we see that more importance is attached to the second contract purpose test as compared to the impossibility test which prevailed in the SARS cases. So this is the change we can see how the courts dealt with the COVID-19 cases in the future. They may deal with such cases in the future. They may take a different approach by applying contract purpose test. The second doctrine under the Chinese law is doctrine of change of circumstances. Well, under this doctrine, if there is a change of circumstances, which makes continuing performance of the contract manifestly unfair, then one of the parties may apply to the court for the court to modify or terminate the contract. Now, this rule was first formally recognized by the Supreme People's Court in 2009. So it did not feature at all in such cases. But now, because it has become part of Chinese law, it has been embodied in the recent Civil Code, Article 533. And therefore, in the judicial documents relating to COVID-19, there is a lot of reference to this doctrine of change of circumstances. We see a wider recognition of this doctrine in COVID-19 documents. So we can see that overall there is a change in a structural sense, where the courts in dealing with COVID-19 cases, they may make more use of contract purpose test when dealing with force majeure cases, and they may make more use of the doctrine of change of circumstances. Now, again, from these all these documents and all the different provisions, I can summarize some notable features as far as the general contractual principles are concerned. And these features are first, I would like to call this a supremacy of party-led solutions. And all the courts, they say universally that the parties, they should renegotiate the contract, they should resort to mediation before they could exercise their strict legal rights. The second point is similar. Now, when they try to exercise their legal right, then the legal right to modify the contract instead of terminate the contract will be preferred. So there is a clear preference for contract modification over contract termination. And finally, this is not a new change or innovation. Instead, it's a firm confirmation of a past practice in Chinese courts, where when the contract is terminated because of force majeure or because of change of circumstances, then the courts will have a wide discretion to say how the loss is going to be allocated between the parties. The only guideline we can see from past cases and documents is that the court will allocate the loss fairly between the parties. So you can see this is a source of uncertainty, but on the other hand, we can see that the judges, they do have these very flexible tools in order to achieve the desirable results they see fit in COVID-19 cases. And finally, we see some provisions relating to specific types of contract, which seem to implement special policies. And these special policies may not outlive the pandemic because they are designed specifically for the pandemic. So in that sense, you can say they are temporary. They are temporary, but they can also be very important. So I will just give some examples of what these special policies are. First, there seems to be a special policy to protect employees instead of employers under an employment contract. So, for example, the employees may terminate the contract if the employer failed to pay salary, failed to pay social security, failed to provide work, even if the reason why the employer fails to do so is because of the pandemic. Still, employees can terminate the contract. On the other hand, employer cannot do that. Employer cannot terminate the contract because the employee failed to turn up for work, they fail to complete the work as contracted. So you can see this is there is a favored treatment of employees in this context. Another example will be lease contract. Some of the documents have made two notable distinctions. One is relating to longer-term lease and short-term lease. Well, the rule is that it is harder to justify a a termination of a long-term lease as compared to a short-term lease. Another distinction is between residential lease and commercial lease. The rule is it's harder to justify a modification of a residential lease as compared to a commercial lease. And thirdly, there is also favored treatment of consumers. The consumers, they are better protected than businesses. For example, under hospitality contracts, if the business fails to provide accommodation, transportation, travel on time or pursuant to the terms of the contract, then the consumers can get out of the contract anytime. And finally, under loans contract, individuals or small or medium-sized enterprises are given more protection in the sense that they can terminate the contract anytime if the bank is in breach of contract, but the bank cannot do so. They cannot accelerate repayment of debt. They cannot terminate the contract if there is late payment in installment. Now we have talked about termination here, but at the same time we see that in order to save some businesses, these documents also provide that if the businesses are liable to pay financial compensation can be reduced or even waived if they really suffer financial difficulties because of pandemic. So what we see here is these documents are trying to do a balancing act, but they do have a special protective policy in favor of these certain group of people I mentioned before. Well, these are the main points I wish to make today. And for further details, you are all very welcome to have a look at my recent piece in Chinese Journal of Comparative Law. Thank you for listening.
Thanks very much, Qiao. It's interesting that the Chinese courts seem to have the same concerns that the government here had. So you've done through the court system what we have done through the legislature, right? Now we'll have Young-Joon telling us what Korea has done. And it's interesting because the northern part of Asia has actually handled COVID better than most. So, let's tell us what's happening in Korea, Young-Joon.
It is indeed my great pleasure to be part of this wonderful academic event. And I'll be focusing on two aspects. Firstly, I will address the rhino aspect on COVID-19 regarding contract law. So far, there have been no special legislation in the realm of private law in response to COVID-19. Therefore, traditional private law doctrines, such as the doctrine of change of circumstances, force majeure, or good faith principle are still valid and are still applicable to those cases. Secondly, I will address policy aspect or administrative aspect of this issue. Although the law basically remains the same, response of the governmental agency in the middle of this crisis may become important. In fact, there are several governmental organizations that utilize their power and authority to protect consumers or laborers. And these measures do have impact on the market. And I mentioned that as well. So the first private law doctrine that comes up is the doctrine of change of circumstances, as have been explained by my colleagues in the previous panelist discussions. There are cases where enforcing the contract on its face would put one party in a drastically disadvantaged position due to the exposed change of circumstances surrounding the contract, and imposing excessively onerous burden on a faultless party who never assumed or foresaw such an unanticipated risk at the time of contract seems unfair. Now, COVID-19 creates such situations quite frequently. In order to materialize this value, putting certain limit on the principle of acta sunt servanda seems inevitable. The doctrine of change of circumstances in Korea is one of the means to set forth proper limitation on these principles, thereby drawing a boundary between the sanctity of the contract and paternalistic intervention to terminate or modify the contract. And such boundary drawing function of the doctrine can also be explained from the perspective of risk allocation. There are cases where contract termination or modification is allowed on the ground of change of circumstances pursuant to certain specific statutory or contract provisions. And in such cases, you can just follow what the law or what the contract says. issue arises when there are no such provisions either in law or contract. And this is where the genuine sense of the doctrine of change of circumstances kicks in. And this doctrine has been recognized by Korean civil law scholars as one of the doctrines deriving from the principle of good faith. And this doctrine was also explicitly accepted by the Supreme Court of Korea in 2007. And according to this decision, this doctrine can be invoked when there's an exposed, significant, and unforeseeable change of the underlying fundamental circumstances, and adherence to an original terms and conditions may amount to violation of good faith principle. However, the scope of its applicability still remains questionable. The Supreme Court has seldom applied this doctrine to a specific case, notwithstanding its general acceptance of the doctrine on the theoretical level. Such reluctant attitude toward this doctrine is also found among the lower courts. Therefore, its theoretical and practical implication on contract law is still considered one of the most intriguing yet unresolved issues in Korean contract law. Given strictness of the Korean courts toward actual application of this doctrine, there is less likelihood that the relief on contracting parties who are unable to perform due to COVID-19 crisis would be rendered based on this doctrine, unless contractual or statutory provisions provide such grounds. Secondly, a force majeure clause may be a ground for modification or rescission of contract due to COVID-19. Force majeure under the Korean Civil Code is generally defined as an accident that the obligor was unable to anticipate or avoid despite exercise of utmost care. Therefore, a force majeure event is an accident occurring externally, that is act of God, including earthquake and storms, or social incidents, including riots, war, and blockades, and therefore any personal reason, such as financial status or absence of the obligor, cannot constitute force majeure events. And as one of the requirements of force majeure, the Supreme Court demands that the accident should occur beyond the obligor's control. As such, since a force majeure event should be an accident that the debtor was unable to anticipate or avoid despite her exercise of utmost care, any accident or event that the debtor was able to anticipate or avoid cannot constitute a force majeure event. Of course, the concept and the scope of force majeure clause should be determined on a case-by-case approach. It depends on how force majeure is defined and illustrated in a specific contract. We can also easily expect that after the outbreak of the pandemic, the parties are more likely to include a force majeure clause that manifestly alludes to pandemic as one of the causes of force majeure. In terms of the scope of liability, COVID-19 can be a cause for limiting liability. The Korean Civil Code expressly provides for a ground for liquidated damages, and the Korean Civil Code also states that the court may reduce the amount of liquidated damages to an appropriate sum when it is considered too excessive. Further, the Korean courts offers a ground on the basis of public policy for reducing penalty when it is overly excessive. And COVID-19 surely may be a major factor to be considered in assessing appropriateness of the amount of either liquidated damages or penalty. Of course, there's a complicated doctrinal issue as to the point of time when appropriateness of amount should be considered. However, prevailing opinion is that the court can consider factors that arose after the execution of contract. Therefore, reflecting COVID-19 that broke out after the execution of contract would not be a problem. And there are other doctrinal issues that are related to COVID-19, such as good faith principle, impossibility, mitigation of damages, and so forth. However, given the restriction on time, I will now move on to the policy aspect of COVID-19. A competition enforcement authority in Korea is the Korea Fair Trade Commission. And recently, its chairperson visited Association of Electronic Companies and Automotive Companies. These industry sectors account for a greater portion of our economy. And the chairperson explained to manufacturers and companies that their position as main contractors tend to be superior than that of suppliers of raw materials, and that they should strive to ensure that suppliers or subcontractors are not disadvantaged by any disruptions caused by COVID-19. In particular, in anticipation of delays in supply of raw materials, the chairperson stated that the Commission will closely monitor relevant industries to ensure that no penalties are unfairly shifted to suppliers. She also stated that imposition of penalties for delay in contract performance during the COVID-19 crisis could lead to a violation of the Subcontracting Act. She also recommended that manufacturers and main contractors are recommended to use the standard subcontracting agreement published by the Fair Trade Commission, which does not count the delays caused by force majeure events toward the duration of delays that are subject to penalties. So based on the recommendation, it is quite conceivable that Korean Fair Trade Commission could potentially raise issues when non-compliance by the companies occurs. And the Commission is also keeping eyes on issues relating to penalty fees for cancellations. Due to COVID-19, the number of cancellations of contract arose, especially in the area of tourism, air transportation, food service, hotel and accommodations, and wedding services. And these are sometimes inevitable because of the governmental restriction. Despite the rise in consumer complaints, Korean Fair Trade Commission does not plan to impose a uniform guideline to determine whether cancellation penalty fees should be waived, considering the private and contractual nature of the provisions governing cancellation penalty fees. Under these circumstances, the Korean Consumer Agency's consumer dispute resolution procedure of private lawsuits are likely to be a primary avenue to contest cancellation penalty fee issues. And finally, the Ministry of Economy and Finance, which is the government authority charged with enforcing the Government Contract Act, has issued the Public Contract Management Guideline for coronavirus. And the guideline provides that when administering public contracts, government authorities or public agencies must issue stop work orders on construction or service provided at sites where work is deemed substantially impaired due to confirmed or presumptive positive cases of coronavirus, and extend the deadline for performance as necessary, and increase the contract price so as to cover additional costs incurred by the contractors. And where the stop work order are not issued, they should exempt contractors from liquidated damages for delays due to unavoidable impairment in work or supply in connection with the COVID-19, and make adjustments to the contract price in accordance with requirements for adjustment. Now in the future, parties will be more actively involved with ex-ante contracting to allocate the risk of pandemic. Second-order contracts, such as standstill agreements, will be made to enable parties to adjust commercial relationships in ways that may preserve more value at lower cost than public interventions. And finally, the value of paternalistic intervention will arise. So this is for my presentation. Thank you very much.
Thanks very much, Young-Joon. Sounds like the South Korean administrative agencies have been very much hard at work in trying to sort out things at a microscopic level. And now we'll have Professor Munin to tell us about what Thailand's been doing. I guess we're back to Southeast Asia again. And we're happy to have Munin with us today because there was a risk that there was going to be a supervening factor that would have prevented him from speaking. But we're going to have him now. Munin?
It's a privilege to speak at this very interesting event. So thank you very much for inviting me. As everyone knows, Thailand has done very well with the health issues. But in terms of legal measures to help, reduce the effects of the COVID-19, I can say is that we have done very little. There is just only one legislation introduced by the government to help a specific group of people. So the majority of of people rely on what we got before the COVID-19. So it may be necessary for us to look at the existing system in Thailand. So when it comes to a change of circumstance in Thai law, we got two systems. The first one is impossibility of performance, and the second one is good faith. I'll give you a little bit more detail of the impossibility of performance in Thailand. The system of impossibility of performance is based on the debtor's fault. We got two rules which were copied from the German Civil Code. According to Section 219, if a circumstance permanently prevents performance without fault of the debtor, it relieves the debtor from the obligation entirely, but doesn't end the contract. We got another rule which can be called temporary impossibility of performance. It's not a real impossibility of performance because it's just temporary. It's Section 205, and I have to say is that we relied heavily on this provision at the moment. According to Section 205, if a circumstance temporarily prevents performance without fault of the debtor, it can be used as an excuse for breach of contract, for delay in performance in particular. This rule was also copied from the German Civil Code. So if we look at the concept of economic impossibility, hardship, or force majeure, the Civil and Commercial Code does mention force majeure, but economic impossibility, hardship, and force majeure do not automatically save the debtor from breach of contract. They can help the debtor escape from the obligation or liability with the help of Section 219 or Section 205. So the debtor will have to satisfy the conditions of these two provisions in order to benefit from hardship or from force majeure. So I can give you an example of how the Supreme Court of Thailand decided on the concept of the impossibility of performance, especially with regard to the concept of economic impossibility. The Supreme Court decision decided in 2002 is a case concerning a company which was affected heavily by the 1998 Asian financial crisis. And the court says that the 1998 Asian financial crisis, which caused the collapse of most financial institutions and gross damage to all business sectors in Thailand, and which severely affected many debtors' ability to repay debt owed to financial institutions, did not automatically render performance impossible. The court needs to verify impossibility of performance on a case-by-case basis in order to determine whether the debtor is relieved from the obligation without liability. So there is no question of hardship. The court did not try to apply like a general principle of hardship or a general principle of good faith. It just rely on the concept of impossibility of performance, and the court rejected the debtor's argument. And then there is another Supreme Court case in an earlier one in 1979. Again, there was a situation where the price of crude oil increased significantly, and the court held that this is not a case of impossibility of performance. The debtor will be required to prove impossibility of performance, permanent impossibility, or temporary impossibility as an excuse for breach of contract. So let's move on to the second system that may help the debtor deal with a change of circumstance in Thailand. I'm talking about the principle of good faith. We got a couple of rules reflecting the principle of good faith. The first one is Section 5 of the Thai Civil and Commercial Code. It says that every person must, in the exercise of his rights and in the performance of his obligations, act in good faith. We also have another section which mentions good faith. Section 368, contracts shall be interpreted according to the requirements of good faith, ordinary usage being taken into consideration. Some scholars suggest that in case of a change of circumstance, Section 5 and Section 368 can be, helpful. If the impossibility of performance doesn't work, maybe we can try to invoke these two provisions. However, Thai courts are quite reluctant to apply these two rules of good faith because their scopes are quite broad. Now let's take a look at what Thailand has done in terms of legislative efforts. Okay, as I said earlier, there is no major change. There is no major legislative change to the existing Thai law. We something like the COVID-19 temporary measures, the one in Singapore. However, there are some small legal and relief measures introduced by the Bank of Thailand, and also we have one legislation in the form of emergency decree introduced by the Thai government. So what we have done so far, the small changes or the small legal and relief measures, I can give you some examples, major examples. The first one is the commercial banks extend the personal and corporate income tax submission deadline from the 31st of March to the 31st of August 2020. And also, the Bank of Thailand, work with major commercial banks, and they, signed a kind of MOU to introduce some relief measures. For example, they agreed to reduce a minimum payment of credit card for 2 years. In the past, the debtor will have to pay at least 10% of the outstanding for each credit card bill. Now, they agree to reduce from 10 to 5%. And also, they introduced a temporary cessation of principal and interest for 3 months for personal loans paid in installments. And also, they introduced temporary cessation of principal and interest for 3 months, or any principal for any principal, or only principal for 6 months for motorcycle and car hire purchases. If the value of the motorcycle is no more than 35,000 baht, if the value of the car is no more than 250,000 baht, for example. And so, and they also have a measure to help SMEs. The government passed an emergency decree, which is equivalent to an act. But this is the only legislation introduced by the government, and this is the only proper law which has been introduced by the Thai government so far. It is called the Emergency Decree on Financial Measures for SMEs affected by the COVID-19. Basically, this emergency decree focuses on 2 measures. First, it's a temporary cessation of the principal and interest for SMEs. And the second thing is the offers of soft loans for SMEs. And we also have the another a small legislative change concerning online conferencing or e-meetings. In the past, when we held a shareholding meeting, the shareholders must meet physically. But now we can do it electronically. We can do it online. Now the Thai society, apart from SMEs, apart from customers of commercial banks, we need to rely on the existing system. And in March, my faculty of law established a pro bono center to help those who are affected by the COVID-19 free of charge, and we do it 100% online, and I can show you the statistics. Out of 80 cases we received, 55% are labor disputes and 30% contract disputes. And so I will show you one case study, of a rental contract. This is a real case. A rents a retail unit in a shopping mall owned by B to run a cafe. The government temporarily closes most stores. A still has access to his cafe, but cannot open it to customers. Does A have to pay rental during the closure? So, A came to us seeking our legal advice because the lessor asked him to pay the full rental, but he did not have any income. He did not have enough money to pay. So they asked us whether he had to pay. The problem is the government doesn't have any, did not introduce any legal measures to help consumers, to help people like A. So what we did, we just rely on what we got in the Civil and Commercial Code. Luckily, we have a provision, section 369. A party to a reciprocal contract may refuse to perform his obligation until the other party performs or tenders performance of his obligation. Luckily we have this provision, and we need a little bit help of the rule of interpretation as well. So what we told A, we said that because when you rented the property, you expected to run a cafe. So running a cafe is an object of the contract, and now the lessor, the landlord, was not able to allow you to use the property to achieve your objective. Therefore, he failed his obligation. The landlord did not perform his obligation. Therefore, under this rule, section 369, A doesn't need to pay a rental in return. So this is how we help the person affected deal with the situation, deal with the effects of the COVID-19. But my question is whether businesses and consumers in Thailand need more legislative change to survive. I can tell you a little bit more that the Thai government set up a committee looking into the possibility of introducing a proper legal measures to help the people with the effects of the COVID-19. We are working on that. And I hope that I will be able to update you on the progress of this. But I'm not really sure whether the government is really serious about this project. But I should end it here. Thank you very much.
Thank you very much, Munin. I would like to thank all our speakers for their wonderful and most enlightening presentations. It just seems to me that things are never what they seem. Dora has shown us that there has been a great deal of legislative intervention in Singapore. On the other hand, the civilian jurisdictions that we have just heard about today seem to be very self-reliant, which goes against what we usually think of their codified laws. So it could be that there's the long-term nature of contracts there. And I was going to say things like good faith, although Munin says that was not really the thing that has helped in Thailand. But this long-term nature of contracts there seems to allow the legislators to leave it to the courts, as Qiao has shown in China, or the executive, as Young-Joon describes administrative measures in Korea, or even the market, as Munin describes self-help remedies in Thailand, right? So it just looks like their societies and economies may actually be more robust than some in the Western world, right? And this could be because the network effects of more financialized and more developed economies mean that things are in fact less resilient. And so there are contagion effects that we first saw with the US subprime problem, which then became the global financial crisis. Unfortunately, this has now been repeated with COVID-19. We now turn to the M&A part of this webinar. I've not looked at the questions yet, but let's now sort of open the questions and have a look at them. Any of our speakers want to jump onto any question in particular yet? Or let's just have a look at them and see who answers what first. Okay, there's one that's clear. So it's to Professor Tjio. This is from Yu Chuanmen. Many thanks for your succinct coverage of Chinese judicial responses. From a comparative law perspective, what's the doctrinal difference, if any, between the common law doctrine of contractual frustration, i.e. hardship and force majeure, and the civil law double doctrines, change of circumstances and force majeure? It seems both function as exceptions to the principle of sanctity of contracts for equity / fairness considerations. Qiao?
I think I will only be able to outline some of the differences between the two. As Dora has described, the doctrine of frustration is a very narrow doctrine in the common law. It is narrow, first in the sense that it requires contract performance being rendered radically different from what is contracted for. So that's a very strict test. And the second point why it's a very narrow doctrine is because the consequence of frustration is contract is automatically off, it's terminated. There is no middle ground. You cannot say that it's partially terminated, or let's change some of the terms. Let's let the contract to continue in another form. Those are not options under common law. So common law is it's a very narrow and extreme, let's say, doctrine. Once you find the frustration, then the contract is off. If frustration is not there, then the contract will be as good as it was before. Okay, so no change is allowed. But in Chinese law, that's not the case. The Chinese law, of course, that's not the invention of Chinese law. Chinese law has adopted the doctrine of change of circumstances, mainly from the German civil law. But in practice, I think Chinese judges have expanded this doctrine in a great deal by applying it to a great number of cases, not only cases involving inflation. The inflation cases is what was the origin of change of circumstances cases in Germany, but it has been applied in China to a great number of cases, a great range of cases. So it's very flexible. And if we look at the consequence, we'll see that Chinese judges, they can modify the contract for the parties. That's not something you will find in the common law system. Common law judges will very, normally they will say very firmly, they are not going to write the contract for the parties. But that is precisely what Chinese judges are doing under this doctrine of change of circumstances. They prefer modify the contract over termination of contract. So if it is possible, they will modify the contract and let it to continue unaltered the form. That's their preferred solution. So you can see that on the one hand, this gives court the power, the latitude, the flexibility to deal with the problem. However, on the other hand, it will damage certainty because parties will have no idea what the result of the case will be. They have to leave the issue to the hands of the individual judge. They happen to, the case happened to find during the process. So it depends on the individual judges. Some judges will be more restrictive in exercising the discretion, some will not. Another difference I just want to mention very briefly is force majeure, as described by Dora, is mainly a type of contract clauses in common law system, but in civil law traditions, it is perceived as a legal doctrine, not a type of contract clause. So it's a standard imposed by the legislature, and the parties normally cannot contract out of. They cannot say this event is not force majeure when the law says it is. So that's also something that you may notice, which there is a huge gap between common law and the civil law, including Chinese law, in this area.
Thanks, Qiao. I think the first question by Mr. Henry Lee would be for Dora. In Singapore, delays caused by COVID-19 impacts may be covered under the force majeure clause in the contract, or if not, the COVID-19 Act. But what about additional costs probably suffered by contractors due to this COVID-19 event? This would include increased material and labor costs resulting from travel restrictions. Do they have to bear the cost themselves? Are they able to recover this from their employer, or is there any other way to deal with this? Dora?
Thank you for the question. Because of what the parties have agreed to do under the contract, essentially contractual obligations are strict. So it would be that a contractor, even if he has to incur increased costs, would have to deal with these costs itself, unless unless it amounts to, for example, a force majeure event, in which case then he would be excused. But I don't think this is what the questioner is asking about. And I think that ultimately, the only way in which the contractor can get the other party to pay some of the costs is if there is a clause in the contract that provides for this. And if the possibility of increased cost is something which the parties want to provide, want to make sure that they provide for, then a contractual clause is the way to go for this.
Thanks very much, Dora. I think this would be for Munin, the second question. In the adaptation of COVID-19 law from German law to Thai law, what were the modifications that were made to adopt it or adapt it to the needs of Thai society? Were there difficulties in transplanting these procedural laws to Thailand?
Thank you. I have to say that we did not adopt any models from German law yet. As I said earlier, the only legislation introduced by the government is an emergency decree aimed at helping SME. We are, a working committee set up by the government is looking at the Singapore COVID-19 Temporary Measures Act as a principal model for any legislative changes. We look at some other countries, but I can share with you now that the Singapore Act is the principal one. Thank you.
All right, we'll stay with Munin because the question by Selina Cheong is actually, because I think you mentioned something about income tax submission delays, right? So her question is, how does a delay in income tax submission help a taxpayer to alleviate difficulties brought about by the pandemic?
Yes. I think I also have that question. We have the same question here in Thailand. But I guess that the government just wanted to give more time to taxpayers to collect documents, because they thought that it was quite difficult to get documents to submit for this purpose. So it just for an administrative purpose.
Could I just
sure,
add that
sure, Dora.
Yeah,
good. We had the same that they had extra time to submit the income tax returns, and I think that Professor Munin's explanation is a good one that probably applies to Singapore as well.
Yes.
The next question is from Lyndon Rom David, but I think I'll address it to Young-Joon, because actually Young-Joon spent quite a bit of time on talking about assumptions of risk and force majeure. So how are contracts on or providing assumption of risk, for example, in insurance contracts, handled in your country's contract law, especially when these contracts on assumption of risk most probably did not contemplate the COVID-19 pandemic? when they were entered into perfected. Because I think, Young-Joon, you mentioned about how the second stage of contracting now would take into account some of these things possibly. So this Lyndon Davids from the University of Philippines College of Law, and says that in the Philippines, assumption of risk is generally exempted from the force majeure doctrine. So if you assume that, I guess, you should not be able to use a force majeure.
Thank you very much for a great question. I believe that most all the contracts have some risk allocation mechanism incorporated in each contract to a certain extent. But there are some types of contract where this risk allocation mechanism is more apparent, just like insurance contract or option contract. So I think it is, after all, a matter of contract interpretation. The scope of the contract or the interpretation of contract will become a very important matter in addressing this issue. For example, it would be very important to interpret whether or not a pandemic or COVID-19 crisis is included in the event that insurance covers. So after the interpretation of such contract, if we determine that it is a part of the insurance events that are covered by insurance policy, then let the insurance contract deal with it. But if it's not the case, then we return to a external doctrines outside the contract, which I've already addressed in my presentation, like change of circumstances doctrine. So my general answer is that it is, after a matter of contract interpretation, especially a interpretation of insurance contracts. Thank you.
Thanks very much, Young-Joon. This next question by Valerie Vitkova, I'm not sure it's going to be fair on Dora because I can't visualize an answer to this, but I'll let Dora try, right? The question is that the Singapore government is regulator, landowner, and promoter of real estate. Which role has been affected most by COVID-19 from a legal perspective, and how will these roles evolve in the future? I guess, how will these government roles as regulator, landowner, and promoter of real estate evolve in the future?
That's a very interesting question. I suppose that the question is asking about the government's role as compared to the private individual's role, because ultimately, I'm just thinking that based on the COVID-19 Measures Act, it doesn't make any difference whether you are the government or whether you are a governmental body or whether you are a private sector body, and I believe that the provisions would all apply. But if you think of the government as a regulator, they would have the power to actually promulgate rules or regulations which they think would be fair. But of course, if you think about that in relation to their role as a landowner, then there might be a conflict there. If we're thinking about the profit motive, then of course, within the government itself, there would be the tussle between which principles should be better principles. I think the third role was the promoter of real estate. And of course, as a promoter of real estate, if any measures are too harsh on the real estate industry, then that's going to lead to hardship as well. So I'm not sure which role necessarily has been most affected, but I would think that the government's role as a regulator would be the most powerful and all-encompassing one, because in that role, it could actually affect the other two roles, which can control and affect the other two roles which it plays, which are mentioned. I don't think I have very much insight into the real estate industry, but Hans, that's my attempt to answer this question.
Thanks very much, Dora. For my 2 cents worth, I think Dora mentioned that some of us are sort of assessors and trying to help solve some of these COVID problems. So one area that has come up is with options to purchase land. And the government has introduced measures to say that if the option fee is to be forfeited after a certain date, the developer will not be able to forfeit it, right? But the market changes so quickly that before you knew it, the developers started extending these options, right? And so issues would arise as to when option fees are in fact forfeited, right? But some of us would even ask another question, which are option fees really forfeited in the first place because the option fee was paid at the start to buy the option, right? So I would say that the government tries to do what it can in a fair and balanced way, but the markets react in such a way because people are trying to protect themselves further, right? Or take advantage of situations that's not possible to predict outcomes sometimes, despite what the government may try to do in its best, the best interest of the country, right? I'll quickly jump to Lance Ang's questions for you, Tjio, because at least that's directed to you, right? Let me just read it out. The contractual relief under Chinese law, including under the SPC judicial documents, is a general doctrine that applies to all types of contracts or only certain specified categories of contracts. And secondly, is there an expiry date or moratorium period for such contractual relief, or is there an ongoing measure, or is this an ongoing measure?
Oh, thanks for the question. Okay, for the first one, some of the things I talked about are relate to general contract doctrine principles. They apply to all contracts over the board. For example, contract purpose test and also change of circumstances, they all apply to all sorts of contracts, but there are certain rules which are specifically for certain types of contracts, like employment contracts, employees' rights, and loan contracts, lease contracts. They all have different rules to cater for the special protective policies in those areas. For the second question, although the provisions themselves do not say what will be the end date, however, there is a very helpful guideline provided by many of the courts. They say the pandemic in China, there is a starting date and the end date for the pandemic. The pandemic is regarded as starting in late January, when the state response level is increased to level 2 in most of the provinces. And the pandemic is regarded as have ended in late April or the beginning of May, when the response level in most provinces was lowered from level 2 to level 3. So that's a very helpful and clear guideline. For all cases, the pandemic will be defined as existing in force in this period.
Sorry, Qiao, don't go off. There's another question from Dylan Ma for you, which is that whether there are any examples of how the people's courts have modified the contracts affected by COVID-19. Are there any guidelines provided on what constitutes manifestly unfair for the doctrine of change in circumstances? For example, if both parties contract knowing that the government may at any time introduce new regulations to combat COVID-19, and such regulations may impede contractual performance, can the doctrine of change of circumstances still operate? Or should it be said that the parties have assumed the risk? So it's a link to the earlier question, I guess, that Young-Joon answered as well.
Okay, I will try to answer these questions very briefly, because this is only the earlier stage of what we think will be explosion of litigation on COVID-19 cases. So we don't see many cases so far, but there is already the first batch of typical cases on COVID-19 published by the Supreme People's Court. Interestingly, all these cases ended up settled by the parties, or settled under mediation. So there is actually no ruling delivered by the court. All the parties, they obviously, as I said before, the courts prefer to resolve all these disputes by mediation or contract or settlement. So that's precisely evidence that the courts are making efforts to achieve that end. In relation to manifest unfairness, this is not an entirely new concept to Chinese law. Chinese courts do not introduce this concept in these COVID-19 documents. Instead, this concept already existed in past law. So I guess what the Chinese courts will do is to derive some past experience from cases revolving around this concept. So what we know is that unlike common law courts, Chinese judges and courts, they will inquire into the substantial fairness of the terms of the contract. They will see if the terms are achieving a proper balance between the interests of the two parties. Okay, if you have a contract which is evidently disadvantageous to one of the parties, then the courts, I would say, would most likely intervene and do something. If parties have assumed risk, okay, so this probably will relate back to a question asked before. What if the parties already allocated or assumed risk in the contract? Then in Chinese law, I think it's becoming clear that in that case, the courts will not intervene if the parties already assumed the risk. In that case, the risk will not be regarded as will be regarded as a commercial risk, and the doctrine of change of circumstances will not apply to a commercial risk. That is a risk already assumed by one of the parties or both parties.
Thanks, Qiao. I think this last question may be linked to just what you just said, but so we'll give it to Young-Joon and Munin as well, I guess. Can it not be argued that pandemics in themselves are not force majeure events, but it is their effects that are? So for example, the regulatory orders around quarantine, immigration closures and performance, and it's the effects that are currently adequately addressed already in civil and common law practice. Young-Joon, you want to try this first, then Munin?
Okay, well, great question. And I basically agree with this argument. Unless there is a very concrete definition of force majeure, including like COVID-19 pandemic, then based on that force majeure clause, it may be considered force majeure. But if not, then it would not be easy to generally say that COVID-19 pandemic may be incorporated into the force majeure clause. So I think it is quite likely that you can argue that pandemics in themselves are not force majeure events. I understand that there are different cases in different jurisdictions. For example, with regard to SARS, I know there's a French court decision where it stated that SARS is not a force majeure, whereas in Germany, there was a lower court decision which stated that SARS is force majeure event. But it should be noted that German court was addressing the case where B2C contract was at issue. It was about travel contract between travel agency and customer. So when it comes to B2C contract, perhaps the force majeure, the scope of force majeure can be expanded a little bit wider. And that's the case in Korea, because as I have mentioned in my presentation, there is a Korea Fair Trade Commission, which is in charge of addressing the issue arising from B2C contract. So in reality, as you have mentioned in your question, it can adequately addressed by administrative efforts like regulatory orders or other measures. Thank you.
Thanks very much, Young-Joon. Munin, would you want to add to that?
Thank you very much for the question. This is one of the most frequently asked questions in Thailand. And as I mentioned in my presentation, that force majeure is not automatically relieve the obligation, relieve the debtor from the obligation. However, I would like to add now that under the labor protection law in Thailand, force majeure is very important to determine the liability of the employer, because there is one provision saying that if the business is temporarily closed, the employer and the employees do not have any work to do, the employer must continue paying the employees 75% of the wages, of the normal rate of wage. But if the temporary closure is caused by a force majeure, the employer doesn't need to pay at all. So the employers in Thailand tend to justify their temporary closures as a consequence of a force majeure. And what we advise the employers who came to us is that it depends on, a force majeure itself is not, the pandemic itself is not, a force majeure. We have to look at the consequence, of the pandemic. For example, if the employer was ordered by the government to close the business, then that is force majeure. But if the employer closed the business due to a financial effect of the pandemic, he voluntarily closed the business, even though he could continue with some difficulty, that is not a force majeure. So I agree with this comment that the pandemic itself is not a force majeure. Thank you.
Yeah, thanks very much, Munin. I think it was the famous legal historian, Professor Baker, who sort of said that the common law was all about rights, in particular property rights, whereas the civil law was all about distributive justice. For a long time, I thought that showed the strengths of the common law and the weakness of the civil law. But in the past years, starting with Mindy's brilliant conferences and all the way to today, sort of made me realize that we have to re-examine some of our premises and beliefs, right? And it might just be that the resilience required comes perhaps more from a civilian type system, right? Anyway, it remains for me now to thank the wonderful presentations and presenters that we've had today, to thank all of you participating in this webinar, and thank you very much. And I hope that we'll see you for the possible 8th CALS webinar in this series. Take care.